Hi guys, it's Kathy. I hope you're doing well. I got so many most important things to say first, and I can't say them all first. So these are in no particular order. Martha, I love you. Welcome back. I hope you're feeling better. Bobby. Listen, Bobby. Listen. I think for the first clip, which is about 47 minutes long, you should definitely mute it and just talk to us in chat. You're not going to enjoy it. This is not a clip for you, Bobby. I mean, look, Eileen. Hi, Eileen. She has no problem doing that. She mutes it. And her life is better that way. She mutes what she doesn't want to listen to, and she talks in chat. Bobby, I'm warning you. This first clip is going to trigger the heck out of you. So you should mute it. Speaking of the first clip, you know how I said in my title on that, this mom needs to be in jail? She does. Absolutely needs to be in jail. But so does the father. So like that part is just so obvious. I didn't put it in the title. But that man needs to be in jail. Big time. Abso-freaking-lutely. They both need to be in jail. Neither of them are going to jail. But they both need to be in jail. Tiffany, our new mod. Tiffany, that's my daughter. she's a mod, a participation mod. Jude, stay away from the weather, okay? Stay safe. It's so good to see you here, Jude. We miss you when you're gone. You and Martha here. Okay. My son is coming too, Anthony. I don't know if he's here yet. Make sure you have it on live chat, not top chat, or you're going to miss messages. All right. Okay, who needs to be in jail more? The father, right? Bobby, I know you're going to say it's the mother. I know it. I get it. You're right, Bobby. You're right. Seriously, I would... Hey, there's Anthony. That's my son. He's a moderator now, but don't worry. They don't know what that means. I just feel like I have to. No, not chop chat. Live chat. Here we go. Oh man, this clip got me shook. I've got to press play. Here we go.
Go to 2506 JP 84. Show father appears in person with counsel. Mother has failed to appear. She was formerly represented by attorney Cassandra Hine. Ms. Collins, have you heard from either mother or Ms. Hine about? I know Ms. Hine withdrew.
Not since she withdrew, Your Honor. I will say I know she sent a letter, it was attached as Exhibit A to her client with notice of today's hearing. The last communication I had directly with mother was when we had a settlement conference. But at that, I have not communicated directly with her since then.
Okay.
And that was back in November.
Okay. Are you ready to proceed?
Yes, Your Honor.
All right. I'm going to allow you to proceed. Obviously, we may have something filed by mom in the future that we'll have to address it, whether it's a motion to correct error, set aside, or whatever, depending on what actual notice that she had. But I think there's sufficient information in the record that her attorney at least was very detailed and sent her notice, which I appreciate when attorneys withdraw, that they've done that. So if you're ready to proceed, you may call your first witness.
And I would call Roman Finnegan.
Sir, if you raise your right hand, do you swear or affirm under the penalties of perjury that the testimony you're about to give will be the truth?
I do.
Thank you. That was security, Levy.
Oh, okay. Do you want him here on the witness stand?
He's fine right there.
All right, state your full name.
Wait a minute.
I've never been here before, so I was kind of confused.
Okay. Well, we're just getting started because we waited a few minutes to see if you were going to make it. What's your name for the record?
Martha, thank you so much. $25. You made mom appear. You made mom appear out of nowhere. She's late for her child custody hearing, of course. Of course she's late.
I'm sorry?
Summer Glover.
And you are mom, correct?
Yes,
And you were formerly represented by Attorney Hine,
yes,
and you're representing yourself today, is that correct? Yes?
yes.
Everything we say is recorded, so we have to say it out loud.
Okay.
All right. So we're going to proceed. Ms. Collins just called Dad as a witness, and then Dad will be questioned, then you'll get to ask Dad questions, and then you can testify, and then they get to ask you questions, okay?
Okay.
All right. Ms. Collins, you may proceed.
Will you please state your full name?
Roman Anthony Finnegan,
Roman, what is your current address?
804 East Lake Street, Knox, Indiana.
And you are the father of Aaliyah, is that correct?
Yes, ma'am.
And Aaliyah's date of birth is at August 24th, 2021.
Yes, ma'am.
Does that make her 4 years old today?
Yes, ma'am.
Okay. And Summer Glover is Aaliyah's mother, correct?
Yes, ma'am.
And to your knowledge, she resides in Westville, correct?
Yes.
Okay. Let's talk about your parenting time with Aaliyah. This case was originally in the Stark Circuit Court, correct?
Yep.
And did you go to court in the fall of 2024 to address parenting time?
Yes, we did.
Okay, it looks like you have a court order from October 25th, 2024, in which the magistrate of the Stark Circuit Court found mother in contempt for violating parenting time. Do you recall that order?
Seven.
Okay. And that order specifically states that there was direct willful violation, continued defiance during that court hearing, in the sense that she essentially said, I will not comply with parenting time. Do you recall that?
Dad, I need you to pull the microphone closer to you because we can't hear you. You just need to speak up, okay?
Now, the judge or the magistrate in that cause had entered a order specifically finding mother in contempt, correct?
They both need to be in jail, Anna, but for very different reasons. It's like, I can't believe the father's not in jail already for bad reasons. Now, the mother, judge should put her in jail because of this. Well, because of, you'll see.
Correct.
Yes, they did.
And also finding that your visits were going to be 2 hours on alternating Saturdays to reintroduce you to your child because you had went a period of time without visitations with your child because of mother's defiance, correct?
Correct.
Okay. So your visits, are they still standing at 2 hours on alternating Saturdays?
We haven't had our visits.
Okay. Well, that's the last court order at least, correct?
Right.
Okay.
Yeah.
Now, the judge in the Stark Circuit Court had entered a review hearing November 20th, 2024, correct?
Correct.
Between October and November of 2024, did mother allow you visitations with your daughter?
At times, yes.
Okay. And when you went back to court, did the judge specifically issue an order finding that reintroduction had occurred, but that you were to continue the visits to keep reintroducing you into your daughter's life?
Yes.
So your visits maintained at 2 hours on alternating Saturdays, correct?
Correct.
Now, pursuant to that order, were you and mother also supposed to agree upon the time and the place of the visitations?
Yes.
Has that proved to be extremely difficult?
Yes, it has.
Let's talk about the visits that you've had. Have you had some visits since November 2024?
Yes, I have had some.
Okay, where do you generally meet at?
As of lately, we've been meeting in Valpo at the Burger King.
Okay, who selects that place?
She does.
Okay, do you get any say in where the visits are?
No.
How long are those visits typically supposed to last?
They're typically supposed to last 2 hours.
Has she canceled any of your visitations?
Multiple
Has she refused to communicate with you in terms of scheduling those visitations?
times.
Has she ever canceled after you showed up at the visitation place?
Yes.
When's the last time you got to have contact with your daughter?
It's been a couple months now.
Okay, so if I said sometime around December, did she just stop visitations entirely? You might have to talk a little bit about
Yes.
this. Did she say anything to you in terms of why she's stopping visitations?
She expressed to me that Aaliyah had stated that she was scared, but I have no understanding of why.
Okay. Tell the court a little bit about how those visits were going when you got to see your daughter.
When I would go see my daughter, she would bring her other children, her significant other, who would constantly interfere with our visit.
How many other children does mother have?
She has 2 other children other than Leah.
Okay. So were you really able to get one-on-one time with your daughter?
No.
And mom's significant other, what is his name?
Owen Davidson?
So this does touch on topic matter that I don't normally play on this channel. Just so you know, it does. We do venture into there a little bit.
Has he interfered with your visitations at all?
Yes, he has.
In what capacity?
Coming up, making comments, telling my daughter that she's been told no when she's sitting there coloring with me.
So they have directly told your 4-year-old child that she is not to interact with you?
Yes,
And you have seen mother do that?
I have seen Owen do that.
You have seen Owen do that? Okay. So what happens when your daughter runs up to you to play with you?
Usually we'll run around and then later on she'll be told, we were told not to do that. Or there's been times my daughter has come up to me and told me that mom said I'm not allowed to talk to you.
Now, we had a settlement conference, correct?
Correct.
And as part of that partial agreement, did we agree that visitation should not include significant others?
Yes, we did.
Did mother ever comply with that?
The first visit after that agreement, she brought the whole family.
Has Owen ever started any arguments with you during visitations?
Yes, he has. He's called me a bum, told me to pay my child support. And as I leave, because he's starting this, whatever it's called, starting this interference involving, during the visitation, I stepped out, and as I'm walking to the car, he follows me out to the car, telling me that I need to get a better job. I'm a bum. I'm a pedophile, this, that, and the other.
Okay, let's talk about this whole pedophile thing. Are you a registered sex offender?
No, ma'am.
Do you have any sex convictions?
No, ma'am.
Yeah, but he should. He should be a registered anyway.
Now, where does this whole pedophile thing even stem from, to your knowledge?
To my knowledge, it's from the age distance between me and Summer.
Okay, how old are you?
I am 24,
How old is Summer?
18.
That was raised prior, back in fall of 2024 in the Stark Circuit Court as a reason why she did not want to allow you any parenting time, correct?
Correct.
So she continues to pursue that despite this already being addressed twice by a court?
Correct.
All right, let's, have you kind of sent me updates on the canceled visitations?
Yes.
And when you email me, is that usually on or about the date of the visitation that was scheduled and then canceled by mother?
The day of or the day after, yes.
You have any exhibits that comes out for me with me?
Every single thing that they're accusing her of, she's done. You're gonna hear from her. It makes you so mad. Wait till you hear from mom. But first we have to hear everything she did first. Although he's no saint.
Is it just one part?
All right, let's start with Respondents Exhibit A here. Let's look at the first page here. Is that an email from you to myself on or about January 22nd, 2026?
Yes, it is.
And were you informing me that you had a visitation that was canceled?
Yes, ma'am.
Okay, and then attached to that email, is that the text messages supporting the visitation that was canceled?
Yes, it is.
These are messages between you and Summer, correct?
Correct.
And that would have been on or about, looks like January 24th to the January 26th, 2026, correct?
Correct.
Okay, basically you're reaching out, trying to confirm the visitation with Summer. Do you generally reach out to confirm visitations with her ahead of time?
Almost every time.
Why do you do that?
Just to make sure that, I'm not driving up there for no reason if I'm not going to be allowed to see my daughter.
She tells you that Aaliyah said that she's scared and she's uncomfortable, correct?
Correct.
Okay, so did she let you have your visit?
No.
She also said that she told you before that she was scared and uncomfortable, and you essentially asked her, are you not coming to the visitation then?
Correct.
Okay. And what was her response?
Any decisions being made are guided by what is in Aaliyah's best interest with her safety and emotional well-being as the top priority. There was an incident in which.
Okay. So basically, she denied your visitations, claiming that it's because your daughter is scared. Is that correct?
Correct.
Have you ever seen?
Yes, ma'am.
Can they please finish what that said? There was an incident that had happened. Roman had yelled at us walking into the Burger King in Valparaiso.
They're gonna attempt to admit it into evidence, so then I would be able to see the whole thing, ma'am. And you'll get to ask him questions in a minute about it.
Okay, but as far as what's concluded here, these are true and accurate copies of messages between you and Summer. Is that correct?
Yes, ma'am.
And they pertain to the missed visitation on January 24th, correct?
Yes, ma'am.
Your Honor, I'd move to admit Exhibit A.
A is admitted.
Okay,
Yes.
go back.
18 is an adult. But listen, just keep watching. I'm telling you, just keep watching. Tita, hi.
A little bit further, I'm showing you what's marked as Respondents Exhibit B. Is that an email on the top from you to me, January 10th, 2026?
Yes, it is.
And does that also pertain to a missed visitation?
Yes, it does.
And then you have an attached text message here. It looks like you're telling her that there's again, message between you and Summer, correct?
Okay.
Through an accurate copy of this correspondence?
Yes, ma'am.
And you're asking to have your visit on January 10th, 2026, correct?
Correct.
Did she ever respond to that?
No.
Did you get your visit January 10th?
No.
Your Honor, I'd move to admit Exhibit B.
Ma'am, any objection to me looking at Exhibit B? I know you wanted me to look at Exhibit A. Any objection to me looking at B?
Is this the exhibit?
They're all,
Those are all the ones I'm presuming that she has.
show you which one they're dated on. Okay, you know, if we were at the top, we would give you the date. So this was, January 10th. This one.
Not what, I'm waiting for Mom to take a look at it first.
Yes, I didn't refuse to do the visits. I actually talked to my daughter.
Okay, you can ask him that in a minute. Do you have any objection to me looking at this document?
No.
Then B is admitted.
I'm going to show you what's marked as Respondents Exhibit C. Starts off with the email on the top from yourself to me, February 23rd, 2026, correct?
Correct.
Also pertaining to a missed visit, is that correct?
Correct.
Okay, the attached message here, correspondence between you and Summer again, correct?
Mm-hmm.
True and accurate copy of the.
Was that a yes? I couldn't understand.
Yes.
True and accurate copy of the conversation between the two of you.
Yes, ma'am.
Okay, where you, looks like you're trying to arrange a visit for February 7th, 2026, correct?
Correct.
You tell her they're court-ordered visitations, correct?
Correct.
Did she respond to you?
No.
And then you reached out again to schedule a visit February 21st, 2026, correct?
Correct.
Did she respond to you?
No.
Your Honor, I move to admit Exhibit C.
Any objection to the court looking at that document, ma'am?
No.
C is admitted.
Okay, I'm gonna attach, showing you what's marked as Respondents Exhibit D. First page here, is that a correspondence from yourself to me, November 15, 2025?
Yes, ma'am.
Also regarding a missed visitation, is that correct?
Yes, ma'am.
Second page here, is that a correspondence between you and Summer?
Yes, ma'am.
On this particular time, you had let her know that you were at the visitation center, is that correct?
Yes.
Was that the Burger King in Valpo?
Yes, ma'am.
What did she tell you?
She said we were on the way, but Aaliyah had a bad diarrhea, so we've got to turn around and head home and head back.
Has she given you excuses before in terms of why she doesn't show up for the visit?
Sometimes, yes.
Move to admit Respondents Exhibit D, Your Honor.
Any objection to the court looking at Exhibit D? D is admitted.
Now, have you had to cancel a visit for any reason before?
Yes, I have, and that's because I was sick and I did not want to get my daughter sick.
And if you can't, do you recall maybe when that was?
I couldn't give you an exact date, no.
Now, if you cancel a visit, do you ever attempt to arrange makeup parenting time?
Yes, I do.
And has she allowed you any makeup parenting time ever?
No, she usually makes me wait until the next visitation.
So I'm going to show you what's marked as respondent to exhibit E. Take a look at those. Are those messages between you and Summer?
Yes, ma'am.
Do those pertain to a visit that you had to cancel that you requested makeup parenting time for?
Yes, ma'am.
And looks like that was a visit you said on November 24th, 2025, correct?
Mm-hmm.
You have to answer yes.
Yes, ma'am. Sorry.
Okay. And when she said, all right, I'll be at Burger King on Saturday, was that your normal visitation that Saturday or a
Yes.
makeup visit?
That was our normal visitation.
Okay, we have a few more questions from the lawyer, and then we hear from Mom. And then everybody gets super pissed off. Just warning you now.
Now, on the second page here, it looks like you're asking her, but what about my makeup time, correct?
Correct.
Did she allow you any makeup parenting time?
No, she did not.
Did she generally ignore you when you ask about makeup time?
Yes, ma'am.
And I move to admit exhibit E.
Any objection?
No.
E is admitted.
Has she explicitly told you she will not do makeup time? You're just getting your regular parenting time regardless if she cancels the visit or you have to cancel. In other words, like have you've had conversations about makeup time, right? Because
Right.
she's canceled clearly. She said, oh, I had diarrhea on one occasion. You had to cancel one because you were sick, correct?
She hasn't specifically told me no, but she has told me that, you know, my next visit is this day and it'll be my next visit.
Okay, so I'm showing you what's marked as respondents exhibit F. Is that also correspondences between you and Summer?
Yes, ma'am.
Also pertaining to a November 2025 visit, correct?
Correct.
And you specifically told her you wanted makeup parenting time on a set date and time, correct?
Correct.
And then what was her response to that?
Why are you switching days around? I will be there Saturday, then 2 weeks after that.
So pretty much you're not getting makeup parenting time, right?
Right.
Exhibit F.
Any objection to F?
No.
F is admitted.
Okay, I'm gonna show you what's marked as respondents exhibit G. Is that a first page communication from yourself to me on November 28th, 2025?
Yes, ma'am.
Okay. Second page, course, second and third page correspondences between you and Summer again, correct?
Correct.
Okay, and are you asking her to confirm a visitation again?
Correct.
And what is her response?
You are a pedophile. It's like you get a thrill out of this. Don't text me like we are any type of friends. You are only trying to make yourself look good over text.
Pretty much, you just asked.
And then I ignored it and said, will we be meeting tomorrow? She said, I'll be there tomorrow at 1:30.
Do you recall if she showed up or not?
Yes, she did. And that is the one where she is saying that I yelled and I did not. I stepped out of the car since she was walking in with her whole family and said that they agreed upon, you know, not bringing the whole family, and they started yelling, I'm a pedophile anyway, outside the Burger King.
document Exhibit G.
Any objection to the court looking at that document?
I can say something about the, what was said on that.
When you get that, if you have a legal objection to me looking at the document, now's when you make it. When you get to question him, you can question him about all of everything that was said, okay?
Okay.
And then you'll get to testify and tell me your version of everything, okay?
Oh, she's gonna.
G is admitted.
Every single day, Kelly. Every day.
We filed a motion to modify parenting time. What are you requesting for parenting time?
Parenting time guidelines.
And you're asking for that to be unsupervised at this point, is that correct?
Yes, ma'am.
Do you have a stable home for your daughter?
Yes, I do.
Do you have a room for her?
Yes, I do.
Do you have any other children that live in your home?
Yes, I do.
How old is the other child?
He is 8 years old.
And what is his relationship to you?
He is my fiance's son,
What's your fiance's name?
Zoe Huff.
Is she pregnant?
Yes, she is.
And when is she due?
Okay, math there did not make any sense, but he's saying she's mad at him because his girlfriend's 18, but she has, what did he say, an 8-year-old? No, she doesn't. I mean, that math doesn't work. Even after everything we're about to hear, which is bad, that math doesn't work. Just doesn't. But she's currently pregnant with his child too.
July 23rd.
Have you had a chance to even tell Aaliyah that she's going to be a big sister to her sibling?
No, I have not.
Aaliyah is 4 years
Is there
old.
any reason you can fathom in your mind why your parenting time would be supervised?
No, I cannot.
Are you involved at all with the Department of Child Services?
No, I am not.
Do you have any pending criminal cases?
No, I do not.
Are you employed?
Yes, I am.
Where do you work?
I work at Apex Brake and Muffler in LaPorte.
What's your schedule?
I work Monday through Friday, 8 a.m. to 6 p.m.
So at this point, I'm like, wow, this guy sounds great. I mean, he has a full-time job, and yeah, they were both real young. So that's not good when this all happened, but he wants to be a dad. He's not with nobody's investigating him. He has no criminal record. So this lawyer has me thinking, wow, this guy's great.
Do you believe with the defiance on mom's part that you need a specific exchange location where you two are going to meet to exchange your child to start your parenting time if the court grants Indiana guidelines?
Yes, I do.
And where do you prefer to meet at?
Jail.
Probably a police station.
Mom should be in jail.
It doesn't matter which town, Westville or Knox, but somewhere that it's public.
So on your Fridays, if you're responsible for the pickup, you could meet at like a Westville police station
Yes, ma'am.
and then meet at Knox on the Sunday fall. For example, if it's the end of your parenting time on a weekend, mom come to the Knox police station or
Yes, ma'am.
sheriff department. You've also filed a rule to show cause against mother and you're asking for her to be found in contempt for your missed visitations, correct?
Correct.
And as part of that,
For anybody new, if you file a show cause, the other person has to come in front of the judge and prove why they did or did not act in a certain way. So the judge says you have to pay a $50 fine and you don't pay the $50 fine. Then you have to come in front of the judge in a show cause hearing to explain why you didn't follow the court order. So she has already been in a few show cause hearings for not following the court order when it comes to parenting time with this child. She's already been found in contempt of court in the past with a different judge.
are you asking for reimbursement of legal fees?
Correct.
Did you pay a retainer to my office?
Yes, I did.
Do you recall how much that was?
I think I paid you $5,000.
And obviously you have some money left over there, correct? But
Right.
would you be asking for at least $1,500 for attorney reimbursement of legal fees to have to pursue this contempt?
Yes, ma'am.
given mom's defiance, is there anything else that you would be asking the court to do at this particular time?
Not at this time, no.
If she is going to continue to deny you parenting time, would you feel that it would be appropriate for her to serve a period of time incarcerated?
Yes, I do.
You pay child support for Leah?
Yes, I do.
And is that through an income withholding order at this time?
Yes, I do.
I noticed there was a roll to show cause filed by the support office quite some time ago. Were you briefly unemployed, transitioning between employment at that time?
Yes, I was.
Okay. And did you fall slightly behind in child support?
Yes, I did.
Have you since been paying extra per week through an income withholding order to catch that up?
Yes, I have.
I have no further questions, Joanna.
Mom, do you have any questions for Dad?
Oh, yes, I have a few. It's kind of mixed up. Did you know that I was underage?
Yes,
And were you okay with that?
we were okay with it, yes.
Did you give me any alcohol?
No, I did not.
I'm gonna object to further questioning. This has been addressed through prior proceedings, their age difference, and this is mom's logic for why dad should not have any parenting time because she was underage when they conceived this child. I don't know the relevance at this point because we have court orders establishing
She was 14.
paternity, custody, parenting time. At this point, it doesn't matter.
Mom, how is it relevant now if it's already been
I
established?
had a file up for a police report.
I'm sorry.
I filed a police report about this and nothing has been done about it in Knox, Indiana.
And when was the police report filed?
The 2024 in October. This whole thing is just really stressful for me, and my daughter does not feel safe around him at all and screams at Burger King and says that a stranger is chasing after her, and that's on tape.
Well, let me, just so I get the picture, because I'm a new judge to all of this.
Yes,
How old are you now?
I'm 20.
You're 20 now?
Yes,
And how old is your daughter?
she's 4.
So how old were you when your daughter was born?
16. I had just turned 16 a month prior.
So she was 15.
When she was
not
born?
14.
Yes.
When they,
Okay, and looks like you guys first came to court to establish this in 2023, is that correct?
Mhm.
Okay. The objection is, how is that relevant to him getting parenting time today when there's already been court orders establishing his parenting time prior to me being involved?
Because this is a serious situation. I was underage at the time and he was okay with it. He just admitted he was okay with it. He could even do anything to my daughter if he was with or without me. And Micah Cox said in court when we were there with him the last time, he said that he doesn't think it's a good idea for her to be by herself yet or at all until she gets to know him.
Which is the reason for the 2-hour visits, correct?
Yes. And Roman, he has canceled multiple visits as well and said he was sick about 3 times in a row.
I think this has already been addressed as far as the age of you were when the child was born, based on what I see from the file. Although I don't see a court, is there a court order that details that, Ms. Collins, or talks to
I
that?
think it's the October order that kind of goes into this is mom's reason for denying him parenting time previous when she was found in contempt because of
If you could just give me the date of the order so I can see it.
October 25th, 2024. Yeah, it's paragraph 3.
Okay. It looks like this was addressed, Mom, so I'm going to sustain the objection about the questions about the age when you and father conceived the child. What do you want to ask?
Okay. He has no indication that he is a danger to his daughter, but I think that point should be weighed more heavily than what the judge is weighing it.
Is it true?
Outside of that,
She was 15 years old, for crying out loud. Come on.
Is it true that you skipped a visit on purpose to go camping and drink with Zoe Huff in April 2025?
It wasn't skipped.
Yes, it was.
No.
There was messages, you guys might have them now.
any other questions?
Not at the moment. What about him skipping visits and then, or coming to visits for 10 minutes and then leaving because he says,
You can testify to that in a minute.
Okay.
You can ask him questions about that now if you want.
okay, do I say that now then?
She's about to testify, and then we get really mad at her. She was not okay so far, like not great, but she was a little bit higher than him in my head at this point, but she's about to ruin it.
You can ask him questions now. If you don't have questions, then I'll get back to you in a minute, okay?
Okay, not at the moment, but if I do, I'll ask.
Any other witnesses, Ms. Collins?
Your Honor, I would call Summer.
If you'll raise your right hand. Do you swear or affirm under the penalties of perjury that the testimony you're about to give will be the truth?
Yes.
Thank you. Ms. Collins is going to ask you some questions, and then you'll be able to talk after that in response to those, okay?
Okay.
Ms. Collins.
Please state your full name.
Summer Rose Goldberg,
What is your current address?
251 West Valparaiso Street, Lot 6, Westville, Indiana, 46391.
You are obviously the mother of Aaliyah, correct?
Yes.
Now, do you acknowledge and agree that you terminated his visitations again sometime around winter of 2025?
No,
You haven't allowed him any visitations since that time, have you?
no.
Why not?
It's not that I didn't allow him, because I never refused it on text. My daughter is not letting me take her out the door to even bring her to go see him to try, because she is generally scared of him.
So your daughter is 4, correct?
Mhm.
And you're telling us that you're not taking her to court-ordered visitations because she's resisting leaving the house?
Yes, with the whole current situation, with how he yells in front of her and stuff, yes. Because she is very scared of him. She cried the whole way home after that day.
Oh, come on.
Yeah.
She's 4. Come on. Bull. A huge, big, gigantic pile of bull. She's 4 years old. Put her in the car. She doesn't know where she's going. What are you talking about?
Beg not to go back.
You're talking about the visit in which you brought Owen to visit sometime, was it
Yes, and
November?
also Micah Cox, he said that it was fine if any kids or significant other, also his significant other, if she came. He said that was perfectly fine.
So I'm just trying to establish some facts. You're talking about a visit in November 2025, correct?
He said at any time it would be fine if in a
I'm
public
not asking you
place.
what Magistrate Cox said, okay? I'm just asking
Okay.
that there was a
It's a
visit you and
public
Roman had
place.
in November of 2025, correct?
Magistrate Cox said it's a public place and he could be there along with my kids.
All right, I'm not asking you what Magistrate Cox said today, but I'm asking you, was there a visit in November 2025 between you and father?
Yes,
And
that he left.
and he left because your significant other started screaming, he's a pedophile in a public place in front of children,
There are
correct?
cameras there. The full story isn't there that he's not telling
Are
me.
you saying that
And
your
his-
significant other was not yelling,
His
he's a pedophile in
significant
front of
other
children?
was there as well. No, never said that. His significant other was there as well.
And Roman left that visit early because of the conflict, correct?
Yes,
Now, you have not allowed him, or let me phrase that, you have not taken your daughter to a visitation since that visit, correct?
my daughter's scared of him. She doesn't. want
Yes or no?
to
Have you taken your daughter to a visitation since
My daughter
November?
doesn't want to go. That's all I have to say.
So that is a no, you have not.
I'm not refusing that. That's what I was told by the lawyer I had. I'm not.
The question was, have you taken your daughter since then?
No, I
I
haven't.
don't know, yelled at
But
is
I
pretty
never
common.
refused.
Your daughter is 4. How much does she weigh?
She weighs 42 pounds.
Can you pick her up?
Yes,
Can you put her in a car seat?
yes.
So you could get her out the door, you just don't want to, right?
I'm not gonna neglect her. That's abusing her to make her do what she doesn't want to do and bring her around a stranger.
Do you think it is in her best interest to have a relationship with her father?
She doesn't know who he is. He's a stranger, and from when she was little, she screamed really loud just by going by him. And I tried when she was little to see if she wanted to have a relationship with him, and she didn't. She was really scared, screaming, crying every time.
Do you think at 4 years old, she should get to decide if she should have a relationship with her biological parent who wants to have a
Yes,
relationship?
I think
with
it
her?
is up to a person if they want to have a relationship with their parent.
You
And
would,
I think it's in her best interest if she.
Listen, my 4-year-old son never wanted a relationship with his teacher, but I got him to school half of the days at least.
She isn't around a person that is with underage people, and there was more than just me.
do you understand that in order for him to develop more of a bond with your daughter, he needs to see her?
Yes, I understand, and that's why I don't think it's a good idea for it to just go straight to unsupervised visits and overnights. I don't think that's the right thing to do right now.
And your preference is he just have no visitations at all and his rights what be terminated?
Maybe in public with a police officer or something, like Micah Cox said before when.
You mean lying that her daughter is scared of her father? Yeah, she's crazy. This mother is criminal. She's not taking this kid to see her father. Now, again, her father is no saint. But the court has ordered her to do something. The court has ordered this woman to do something. But the thing is, like, she's not lying. She's telling the judge straight out, I am not going to follow your order. Period. She's not even trying to lie to save herself.
All this first started.
Nothing further, Your Honor.
Ms. Glover, what would you like to tell the court?
I would like to tell the court that my daughter does not feel safe around him. Every single visit she went to, she either screamed or yelled or ran away or hid by me.
What else would you like to tell the court?
I would like to tell the court that I don't think it's in her best interest if there's any overnight stays or unsupervised.
Anything else?
No, not at the moment.
Tiffany, you were allowed to pick your snacks as long as they were exactly what I already had planned.
Have any other witnesses or any other questions?
No, Your Honor.
Do you have any witnesses that you would like to call?
No,
Do you have anything else you would like to tell the court?
not at the moment.
Okay. Ms. Collins, what are you requesting at this time?
Your Honor, I think we
Jail.
need some extreme measures in this case
Jail.
because of the amount of defiance on Mom's part. I mean, I've been practicing since 2014, and it is shocking to me how much she just defies court orders over and over again. And just blatantly, I'm not going to do this. She may want to terminate his rights because of their age difference that's been addressed years ago. At this point, he has rights to his daughter. He has the right to see her. And with Mom controlling the visits, the time, the location, the supervision, zero progress is being made. I don't think there's any finding that he is a danger to this child, that he will significantly impair the child's emotional well-being. I think the Stark Circuit Court tries to do some transitional parenting time just to get the child acclimated to being around him. If you listen to my client, they have fun during the visitations, but it's just significantly interfered with by mother and her boyfriend. So at this point in time, we're asking for the Indiana parenting time guidelines, or really quick progression to the Indiana guidelines, unsupervised parenting time. And we are asking that mother be found in contempt, that she be ordered to reimburse legal fees in the amount of $1,500. I'm happy to file an affidavit when I get back to the office.
This is her second contempt or third. I don't know. They should be asking for custody at this point. They should be saying, you know what, that's it. It's enough. We want custody. Look, her hand's in the air. It's fine. The judge is about to get her, not like I want him to, but this is just the beginning. He is new to these two people. So he's going to lay down the law and see what happens from there.
And quite frankly, whatever else this court thinks may be beneficial to get her to finally comply with some court order parenting time. I'm open to a review hearing in a few months as well, so we can check in on progress.
And Mom, what are you requesting from the
There
court?
should have been a court order filed from Cassandra Hine about the child support and stuff, and him being held in contempt for not paying for over 3 months, and him also paying my legal fees because I paid over $3,000 and nothing was done because it took so long to come to court.
What are you requesting as far as parenting time?
I'm requesting I don't think it's best interest at all to have the unsupervised. I think that's a very bad idea.
What is your significant other's name?
Owen Davidson.
And he goes to the visits with you when you take your daughter to see her father?
Yes, and he plays with the other kids in the play area.
Yep.
Or he goes and gets us something to eat.
Four-year-olds don't get to determine their lives. They don't get to pick their bedtimes, right?
Yeah.
My 22-year-old doesn't get to pick his bedtime. Anthony, go to bed.
They don't get to pick whether they go to school or preschool. They don't get to pick and choose most everything important in their life. Do you agree with that?
Yeah, but I also think that it's not okay for little kids, especially little girls, to be around somebody that likes underage kids. I think that should at least be evaluated.
I agree with
This
that
has me
statement.
very scared because my daughter, she is a little girl, and he is over age. He was over age at the time.
Well, here's my question. Since the parties can't agree whether it's light or dark outside, and they're never going to agree on situations as far as the supervised parenting time, why haven't we done Harmony House where dad can be with his daughter without mom, with somebody else there watching, so that dad can get that time?
I think we could do just this unsupervised, at the Burger King, we could still do that.
No, Your Honor.
It's not working, ma'am.
We actually agreed to that, Your Honor, back at the conference, and Mom refused to sign an agreement.
I never agreed with that with Mrs. Hine.
Okay. Well, that's what this court's going to order.
Okay, well, I think it should at least be evaluated first.
I think he's 24 right now. The daughter is 4. So he was 20 and she was 15. That's what it sounded like. Because she was 16 when she gave birth. She was 15 when they conceived the child. He was 20.
Before she's around him, because like I said, she is very scared of him.
Ma'am,
I'm actually considering taking her to therapy because of it.
there's been no evidence presented.
And I'm not able to
Ma'am?
go up there and do that in South Bend, I think where it is.
This is in
Because
Laporte.
I only have one car.
This is in Laporte.
Do that during the week.
This is in Laporte. You will have to do it, ma'am. Otherwise, there's going to be sanctions from this court, including, possible issues involving you having your own custody of your daughter and possible incarceration of you. So family advocates has professional people that are trained to be there. They write down everything that occurs between dad and daughter. They're never alone. And they give a unbiased view of what happens. So it's not your opinion of what happens. It's not dad's opinion of what happens. It's somebody else who's trained to do this.
Okay,
And that's what I'm going to order start taking place once a week for a period of 2 hours so that this can proceed and see if dad can have a relationship with his daughter. If you take your daughter to counseling, that's great. Take her to counseling. Then we can get a counselor's opinion as to what's going on.
okay. Can we by chance keep it at the once every 2 weeks, like Micah Cox had it?
Oh, I thought it was once a week now.
No, it's once.
Is it every 2 weeks now? Yeah,
It's every 2 weeks.
I want to keep it on the same schedule it is now. So every other week. I'm sorry. I thought I misheard. It was every week at Burger King. And I didn't get a chance to read in detail all of the text messages yet. I just saw the content of kind of the conversations back and forth. So every other week for a period of 2 hours. Today is March 9th. I want this to begin next week. It's going to take you guys that long to get signed up, to get over there to do it. Mom, you're going to pay any expense related to you. Dad's going to pay an expense related to him. Otherwise, it'll be split 50-50 for the cost of this.
He agreed to pay that cost when they talked about that.
I understand that back then, but I've got so many court orders that have been violated up to now. You're going to have to pay some of that cost, ma'am.
Okay.
I'm going to.
Stay at home. I'm not really able to pay that. That's why I was.
They have a sliding scale and they'll take your income into consideration. I'm going to take the request for attorney fees under advisement. We're going to set this out for a review so I can see if you're complying, because if you're not, then
I don't have a job to pay the.
I understand. I understand. And they're asking for $1,500 in attorney fees.
Yeah, I don't have a job.
And they're asking for possible incarceration, which then we move to a second stage of this where there's sanctions and other things. But I'm brand new to this case. I'm going to see how things go for me, see if you follow my court order and go from there.
Judge, I'm brand new to this case too, and she needs to go to jail. Look at her. She is right now not listening to you right this second. She's telling you point blank, I'm not paying for that. I ain't got no money. Get a job. Sorry. Monica, we are twins.
What would you like to say?
Okay, and what about how he wasn't paying his child support for 3.5 months, and I think Cassandra and did.
First off, that 3.5 months with no child support, that's child's play. That's nothing. Try years. Try that. He's paying his arrears. He did go 3 months without paying child support. He admitted it. He got a new job, and now he's paying arrears. Like I said, he's no saint. He is not thousands of dollars behind. And we see people $50,000, $60,000, $70,000 behind in child support. And he never paid one child support payment. He never gonna. He missed 3 months, and he's paying arrears, as he should with the child support people. She doesn't have a job. She doesn't work. That's worse than missing 3 months of child support payments.
File something for that.
That I didn't see. That wasn't set for hearing, but you can go to the child support office and see if they will enforce that for you.
They did, Judge. They
All right.
presented
We've
that
got-
That's what
earlier,
it was supposed to be today.
We've got June 1st at 3:45 p.m. for a review hearing. So you're ordered to be back here June 1st at 3:45.
State that week.
You are? Okay. Let me find another date.
I can do the following Monday, if that's fine,
That's fine, that
the
works.
8th.
She has a boyfriend or
My
husband.
man got scheduled in June, but I just thought it'd be like.
Remember, he keeps going to the visits and yelling pedophile to this guy. She keeps bringing him along to this guy's visitation with his kid, and the boyfriend or whatever plays with the other kids in the playground, and that's okay with her. It's okay with her that her boyfriend is playing with these other little kids in the playground. But it's not okay with her for him to see his daughter, which I kind of don't 100% disagree with. But that's fine. She does need to follow what the judge says, though. That's not fine.
Like it before 3:45, because we do have some slots open.
No,
No.
3:45. So you can do the 8th, Ms. Collins?
The 8th works.
So you're ordered to be here June 8th. My court reporter will give you a reminder slip at 3:45 p.m. And that's to make sure parents.
We won't make it that far. That's 3 months away. There's no way she's going to make it more than 2 weeks. No way she's going to listen to the court orders. They're going to have an emergency hearing. I know it. Don't worry. I'm going to get it. I get all of his dockets. We're going to see them again before 3 months is up.
Parenting time is taking place, I'll be able to see how things are going. If you get your child in counseling, great, get her in counseling.
How's she going to pay for that?
I've never, in 33 going on 34 years, I've never seen counseling harm. I've seen it help. I've seen it not do anything, but I've never seen it harm. So I think that's something that's good for a child to be able to at least engage with somebody who's not mom and who's not dad, and maybe
Yeah,
can
she
talk
does.
to them through their things.
Oh, Judge, you're talking to a lot of Gen Xers here. When we were young, the ladies, when we were young, our counselors told us to smile more. If we didn't like something, maybe we should try smiling more. So, never mind.
So I'm going to order the parties to begin. Today, you need to reach out to family advocates. We will be sending an order over there today that you guys are going to begin, and that the review hearing is set then for June. Any questions, Mom?
I would like to ask that since I'm not allowed to be there, can his girlfriend not be there, please?
It's only going to be him.
That's disrespectful.
It's only going to be him.
Okay, thank you.
It's going to be Dad. You drop off, and then the child, and then he's going to come. You guys are probably not going to pass.
I'll pick her up at the same building.
Right. It's in LaPorte, right
I'll
on.
drop her off there and pick her up because I
Correct.
don't want her in the same car as him.
He's going to be there waiting for her, and then you're going to pick her up and drop her off.
Okay. Also,
And family advocates will give you instructions on how that goes.
state that he doesn't have his own car and he also doesn't have his own place to stay. He lives with his mom.
Well, right now, he's going to be seeing her at a separate place, okay?
Okay.
All right. So I'm going to do a quick order on that today, just so we get it over to family advocates so that it's there, okay?
And of the house, how he lives at his mom's house, is that what you were putting in there?
No, he's not going to be seeing the child at his mom's house.
Okay, because they also have cockroaches there that is put in there from Micah Cox.
And the child is not going over to his house.
Okay.
And before you leave, please update your address and email with the court reporter so that any orders will shoot directly to your email, okay?
Okay.
Anything
Thank
else, Ms. Collins?
Okay.
Okay.
I don't pick my bedtime right now. I go to bed when I'm tired. Okay. All right. I don't even know what I'm about to show you. Listen, I don't even. I'm just gonna press play.
Sit down a little bit, please, God.
Can't wait for me, please, God.
All right, Cynthia, we'll start with you.
Hi.
To 2603 CM 146. Cynthia, you're charged with false informing. The state of Indiana says you gave a false report of the crime, knowing the report information to be false, substantially hindering the law enforcement process by resulting in one or more officers being dispatched to a major hospital. Do you understand that?
Yeah, I didn't know if it was false or not. I called it in just in case it wasn't. I didn't know, and I told him I didn't know if it was true or not, but just in case, I was calling it in.
All right, let me read the police report here.
I don't know what she said there.
And I even gave a name on here, tell me.
I did cut some of it, don't worry. But not yet. What is she looking at? What is she doing? Cut it out soon. I just it made me laugh so much that I kept it in. What is she doing?
All right, I found there's probable cause. I'm gonna set bond amount of 50,000. Cost you $50,000 to bond out.
50,000?
Yep.
Come on, Reagan. You know I ain't no threat to anything. My lawsuit's going down right now, and Homeland Security just named herself out in helping me. I mean, come on, Reagan.
I'm gonna Judge
I'm
Riggins.
not a threat for nobody.
I'm gonna appoint Warren to represent you. You can talk with him about it.
All right, I mean, can you have him come see me? I ain't like he's gonna come see me until the day before court.
Yeah, I'll tell him come see you, Nikki. All right.
I don't know what she's saying. I don't know. Boomhauser?
Why are we doing this to me, Riggins?
Because I'm trying to protect the public.
I mean, you know I'm no danger to the dang public. When I'm trying to clean up, Shelbyville. And I've got several officers helping me and 2 detectives working with the FBI for me. Why do you keep drowning me in here?
Well, it's just.
The thing I did was call to make sure nobody got hurt.
I appreciate
What I
it.
did.
We'll talk about that later. That's what the bench trust for.
So I get to lose everything in the new house I just moved into again, just like you guys did me last time. And you guys want to stop doing this.
April 20.
I'm over it. And I know a judge is being blackmailed. Okay, I already know. I'm not done.
All right, April 29th at 8:30
Why
a.m.
April 29th? Why can't it be March like the last two?
And your bench trial will be the next day.
All right, well, then I know who the judge we're going after. Obviously, I thought it was Judge Riggins. Yep. I thought it was Judge Riggins.
You can leave. That's okay.
Oh, that's fine.
Good luck.
I don't know.
I had to keep her. I was going to stop there, but I had to get this one too because I was enthralled.
Oh, that's fine.
All right, McKenna, you're up next. So,
Last one.
hi, McKenna.
Hi, Riggins.
Judge Riggins when I'm on the bench, okay? All right. You're charged under 73D02 2603F681 with possession of methamphetamine, a level 6 felony. The state of Indiana alleges you didn't only possess methamphetamine on March 11th. Do you understand that?
Yeah, Riggins. I didn't know if it was mine or not when it fell off the floor.
What's your address, McKenna?
14, Washington.
Fairland?
Yeah, I think so. I'm pretty sure that's it. I'm pretty sure that is.
Do you have a phone number?
I don't know it. No, I don't think my phone. I don't know my phone number.
Where the heck was she in the 80s? Remember, this is your brain. This is your brain on drugs. We did not need an egg. We needed this clip right here.
No.
Do you have email you check on a regular basis?
No, I don't. I don't have any email or anything either because I don't know my phone.
Who do you live with on that?
Troy Wade.
Troy, what's Troy's last name?
Troy Wade. Troy Wade. Troy Wade. Troy Wade.
Can you spell his last name for me?
WADE.
Okay.
Troy Wade.
How long have you lived there?
I've lived there for about a year now with him, and I just have found it on where it came from. But I've been living there for about a year.
Do you work?
No, I haven't been doing any jobs since I've been working there. Whenever he gets a job at the Monlo Lanes, I go and get the Monlo Lanes too. I work with him when he works.
Okay. I'm reading the police report, McKenna.
McKenna is such a pretty name, though. I have no idea what she was saying. None. Zero. Now I know what Brent feels like when an Australian hears a Georgian accent. Now I get it. Maybe that is what she said, Jude.
Yeah, I just got in a little fight with my boyfriend. I didn't really know what was happening, and so like I don't think it's fair that I'm in here. Like I don't think anything is fair. Like it was just a little fight because
I'm waiting for her to hold up her thumb. Look, I lost my finger.
Still reading the police report, McKenna.
okay.
Yo, that is a long time for her to be quiet, though. She's doing good. She is. I lost my thumb. I don't know if you can see it. Something's growing in my thumb.
All right, I found there's probable cause. Are you going to hire an attorney to represent you in this matter?
Yes.
Yes? Okay.
All right.
Are you going to pay for a lawyer if you're not working?
Yes.
Yes, what?
Yes, I'm going to hire an attorney. Yes, but
Okay, all right. I'll set the matter for status of council hearing on March 23rd, March 2-3. If you've hired a lawyer by then, you do not need to appear. Otherwise, you got to be here. Your final pretrial is May 4th at 8:30 a.m. Your jury trial is May 11th at 1:30. Your bond is $7,500, 10% cash law, cost of $750 to bond out. Do you have any questions?
yes, does that mean I'm being released?
If you post a bond amount of $755, you are. If you don't post the bond, you won't be released, McKenna.
Oh man, can you do what you did with the first one and release me today?
No, the first one had no prior criminal history, was a misdemeanor. You've got a lot of prior criminal history and you're here on a felony.
Oh, it was an accident though. What happened was an accident, was a little small fight.
Well, that's something you could talk with your lawyer about that you hire. That doesn't mean you're guilty, but
I was got released. I feel like I'm supposed to be released today.
Well, I'm sorry.
I need to be released. You really brought me there. I hate it here.
You're going to be there a little bit. Okay, that'll conclude your hearing, McKenna.
Thank you so much.
Hey, Judge, real quick to clarify on,
That's right.
Hanover.
Yeah.
That's 50,000 cash and then next court date of 4/29 at 8:30.
Yes.
Thank you, Judge Williams.
You're welcome, McKenna. Thank you.
Thank you.
Okay. We haven't seen Judge Francisco in a while. Let's go. I don't even know what Judge Francisco looks like because we never do actually get to see him.
Who do you want to start with?
Oh, let's start out with Dwayne Shern. Mr. Shern?
All right. All right, this is State versus Dwayne Shern, 2603 MR3. Mr. Shern is in custody on video. Mr. Lenyo is in court. State by Chief Deputy Golubieski, Deputy Rawl. Mr. Shern, can you hear me? The Zoom went out for a minute. Are we still connected?
Yes.
All right, Mr. Shern, I'm setting your case for trial, sir, on Monday, June 15 at 11 a.m. Do you acknowledge that to be your trial date, sir?
Yes.
You understand if you're not here, we can still have trial without you?
Yes.
The record date, sir, is May 26 at 9 a.m. and the status date is April 21st at 9 a.m. Do you acknowledge those court dates, sir?
Yes.
You understand that if you're not here or if you're in custody and you refuse to come to court, I'll issue a warrant or I'll hold you in contempt.
Okay.
All right, Mr. Shern, your attorney, Mr. Lenyo, is here. I think he's already looked at the case because he filed a motion to compel compliance with 353412, correct, Mr. Lenyo?
Yes, Your Honor.
Now, your complaint is that the charging information only lists one witness who is, in fact, the alleged decedent, and then generically lists all witnesses listed in police, medical, and laboratory reports.
Right.
And you're asking if they don't do that for the case to be dismissed, right, Mr. Lenyo?
Correct.
Now, do you have any authority that shows that that would be the remedy under these circumstances?
I do. Well, the one case where that argument was made was Greer versus State, 543 Northeast Second, 1124, and that argument was made there, and the language was such that
What year is that case?
it's a 1989 case.
All right, because mine's 81 from the Supreme Court.
Yeah, this is Supreme Court from Greer.
No, I have Lay versus State,
Okay.
which is 428 Northeast Second, 779. The language I'm reading is this. The purpose of a pretrial discovery order and the statute requiring witnesses to be listed is to enhance the accuracy and efficiency of the fact-finding process, citing Bruce v. State, a 1978 case. The remedy for violation of the statute's requirement depends upon the circumstances of the case, and ordinarily an adjournment or continuance of the trial for a deposition is sufficient to place the party in as good a position as he would have been in had the statute or order been strictly obeyed. Now, I also note that the state has filed, at least preliminary discovery, which seems to entail a lot of police reports, search warrants, interviews with persons, and photos, correct?
Well, the police reports really are kind of light. There aren't the police reports. There's a bunch of body cam and that type of thing. But in terms of the actual police reports, most of those have not come through yet. My primary purpose is essentially just having the state comply and getting the witnesses.
Sure. I understand that, but we're far too early in this game for me to be considering dismissal on a violation of this statute.
Right.
So, Ms. Golubievsky, what are your thoughts?
This is Mr. Beckwith's case.
Okay.
I'm covering for him, Your Honor. Typically, what the state does in a case like this, there was a quick turnaround from the elect.
That sounds like a new bucket list idea for me. Golubievsky. Her last name is Miss Golubievsky. I have a new request for my husband, my future husband. His last name has to be Golubievsky. How do you spell that? I don't know. Just write G something down. You'll be fine.
Incidents to the time of filing, that the state files the information with their listed decedent and makes that broad caption of including everyone in the police reports. It's typically the practice of the state then to amend the information later on as we gather more police reports to add additional witnesses and when discovery is completed. So I don't think it hasn't been an issue in the past, and I don't anticipate that'll be an issue here. I think just because of how quickly Mr. Shern was charged, and he was charged over the weekend just for processing paperwork and everything, that's how the information was charged. But typically the practice of...
I thought there was a P in it, Golubievsky, but maybe it was Golubievsky.
If that's a concern for Mr. Lundio, then I have no issues filing an amended information. I don't necessarily think that would be necessary, but I have no issues directing Mr. Beckley to do so.
We can't even agree on Gala. The chat can't even agree on the first 4 or 5 letters. I would love that last name.
Information that Mr. Lundio needs, surely the state will provide it to him. But as we obtain discovery, we give it to Mr. Lundio, and there's additional reports that are probably still outstanding, not knowing too much about what's going on, but this was a fairly recent incident. So,
All right. Well, I mean, I'm familiar with signing amended informations that merely add the name of witnesses up into essentially the day before trial, and there's never an issue. Typically, this is an issue if the state wants to continue a case or a trial due to unavailability of a witness, and that witness is not listed on the information, then that continuance would not be granted. But why don't we go ahead and do this, Ms. Golubievsky, have Mr. Beckley. The thing is this, if you're not amending the substantive nature of the charge, you're just adding witnesses. I don't want to keep having initial hearings or hearings on that. Would you?
Okay, we heard enough from the lawyers. Now it's time for him to talk. Thank you so much for the 20 gifted memberships. People really, 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 really love those. They really do. So on behalf of all of them, thank you so much.
Do you agree, Mr. Lenyo?
Yes, what my suggestion is that perhaps we give them 14 days to submit what they have in terms of the witness list. I'm not asking to do anything other than just have them do that.
All right. So Ms. Golubievsky, go ahead and have Mr. Beckley file an updated or at least an amended information that updates the list of material witnesses within the next 14 days.
No problem. One of the issues that has come up is that the court has set a trial date during a time that Mr. Beckley will be out on vacation.
Oh.
So he will be out of vacation June 18th to the 30th.
All right. Well, I'm glad you brought that up to my attention now while we're all here.
Yes.
So June 18 to 30.
That's when he'll be gone, yes.
All right.
Excuse me, Your Honor.
Yes, sir.
I want to invoke my right to a fast and speedy too, please.
Well, Mr. Shern, do you have counsel? So
Yes. I know this is against my counsel, but this is this is me.
Well, I'm going to note for the record that you've made that request pro se.
Right, this is the initial appearance. I just want to be on record.
Okay, and it is on record. I'm going to deny it because the case law does not allow hybrid representation. That is the motion.
I'm asking my attorney now to invoke for me.
Okay, well, and he's heard you.
Mr. Shern,
Please.
I've met
Thank
with
you.
you. I've met with you twice already,
Yes.
and I've been working on your case. But and this is something specifically we talked about. But
Yes.
I also advised you that there's a lot of work that goes into these cases, and at this
That
point,
ain't my problem.
what's that?
All right,
That's not my problem. I want to invoke my right to a fast and speedy, please.
It is your problem because the council
Give me
needs
that
to be
sheet back.
prepared.
Okay, well, that's what I want to
Mr.
do.
Shern, hold on. You're going to have a conversation with your attorney, but you can't do it now because right now it's being broadcasted to everybody, okay?
Okay.
All right, Mr. Shern, I'm going to move the case up to June 8, not 15. All right, so the trial date is June 8 at 11 a.m. All right, right now, do you acknowledge that to be your trial date?
Yes.
All right, you understand if you're not here, we can still have trial without you.
Yes.
Now, that's not during Mr. Beckley's vacation, right?
No.
All right, the other dates, Mr. Shern, that I gave you remain the same, okay?
Okay.
All right. Anything else, Mr. Lenyo?
No, Your Honor.
Anything else, Ms. Golubievsky?
No, Judge, thank you.
All right, Mr. Shern, at least for now, we'll see you next on April 21st, okay?
Okay.
All right, thank you.
Josh.
Who's
So-
next, Mr.?
If anybody had seen the video I put out on court disorder today, this guy did that to this attorney after this poor attorney had already gone through all of that today. So it was great. All right. sugar. I have 2 more things I want to show you, and I don't have time. But you know what? We're just gonna make time, because this is short. I'm gonna show it.
Calling cause number 2025-57385. You can have a place at council's table. And let me go ahead and take announcements, please, for the plaintiff. Right?
Byron Banick.
I'm sorry?
Byron Banick, B-O-E-N-I-G, representing Ms. Moore.
B-O-B-I-N-G.
B-O-E-N-I-G. Like a confused Boeing with not quite the right letter.
Yes.
Why would you bring up Boeing? Why would you confuse everybody like that, sir? Rude.
And Jesse Guadiana for defendants, Cindy Rodriguez and Israel Rodriguez.
Spell your last name.
G-U-A-D-I-A-N-A, like Diana, G-U-A, Diana.
Okay.
Stop. Stop. Like Diana? Nothing in your name is like Diana. Just like nothing in his name is like Boeing. Stop, both of you. Okay. This judge is about to yell a little bit.
I'm clear. Mr. Guardian?
Guadiana, yes.
Guardian.
I'm with Greg Howard with Germer.
You're what?
With Greg Howard and Germer.
Okay.
Gorion, like Diana. Sorry.
Are you representing him as the plaintiff or as, I know that Germer was involved.
Yes, it still is. In the limited scope for defending the negligence claim against them.
Okay, and you are representing him on what?
Israel and Cindy Rodriguez on the negligence claim.
What is Germer doing?
I am with Germer. I am.
You are with Germer.
I apologize, Your Honor.
Okay, so I was confused. Thank you so much. So you are representing him as the representative of his homeowners homeowners insurance.
Correct, Your Honor.
Okay, on the negligence cause of action that she asserted. Okay, are they planning on being here?
No, Your Honor. No.
Okay. Let me just pull up this file in a minute. All right, you are all here on this motion for continuance.
Yes, Your Honor.
It's more like Kathy. Like
why would I ever grant a continuance?
Our offices were retained on the 20th of February. We've been involved in this 2 weeks right now. I have spoken with Mr. Howard and Jesse here both. I believe at this point, we're at a point where mediation would be fruitful. I think both of us have a good enough relationship with our clients that'd be worthwhile. To that end, we have scheduled a mediation with Norman Roser on March the 24th. On my end, I'm looking to get a little bit more time because if this cannot be resolved at mediation, I'm just so far behind the 8 ball. There was no more discovery or anything I can do. The vast majority of this case, she has represented herself pro se. So
I am well aware.
I'm sorry?
I am well aware.
I'm sorry, Your Honor. I'm not trying to say anything in disregard to that. I'm just laying out my reasons and what I'm trying to do because as a pro se party, there was a lot of things that were not completely done and not completely ready. And I found out I'm facing.
Look at this from the size of this file, which is about 10 pages long. Did you look at the court's file?
I do understand, Your Honor. And I do understand the court's concern of not wasting time and not having any more. At this point, I try to proceed forward with trial. I believe it's going to be difficult. I believe there's a lot of issues there that can simply be resolved at mediation, and this can be done. I have spoken with my client. She has confirmed that she does want to mediate and does want to get this resolved. So I took steps to get a mediator, someone that I know is familiar with this type of case. I've dealt with Mr. Roser in the past on almost exactly the same type of boundary disputes and neighbor disputes. So I know he's very well aware of the law, very good at being able to talk to the people and make them understand where it's happened.
You're in agreement with this motion, correct?
Yes, Your Honor.
Okay, I'm gonna hold on my ruling. The mediation that you have selected is within the period of the trial docket.
Okay.
All right, so I will not call you the first week.
Okay.
All right, but I am not taking you off the trial docket. I really want this case gone.
I understand, Your Honor, and I want to do the same thing.
Both need to tell your clients to stop filing stuff directly with the court. Okay, these requests for in-camera review documents is a clear attempt at ex parte. I mean, stop. They have to stop. If they don't, you're going to trial because it's the only surefire way I can get rid of this case.
I understand, Your Honor, and I can assure you that my client will not be filing anything. I will
Talk
be.
to your client, even though you only represent him on half of this case, cannot be filing things and telling me I have to keep it a secret.
Judge, don't tell the other side this. Can we have a meeting?
Yes, Your Honor.
Okay?
Yes, Your Honor.
So for Ms. Moore's sake, I did not file anything and told them to come and pick it up and leave me alone. Y'all are probably going to go if you don't settle that case.
So my understanding at this point, Your Honor, we remain on the trial docket. We'll notify you once the outcome of the mediation occurs.
Yeah, if you don't settle on the 24th, you can plan on being here on the 25th for trial.
Understood, Your Honor.
Understood.
Okay?
Yes, Your Honor.
Good luck.
Thank you.
Thank you, Your Honor.
Okay, all right. Now I'm going to do exactly what I promised to do. I promised. This is from, okay, remember, we're behind. We fell behind on our court cases because we've so much to do and we fell behind. So this is from March 6th. I do understand it's the 15th, but it's Sunday. So there was no court today. There was no court yesterday. So really, 13th is the last day. And I think Judge Fleischer might have taken off at least one day. I don't know if there's more. But regardless, this was from the 6th. I picked out just a couple of cases.
What was the last name, Sarah? Just the last name.
DAS.
From his docket on the 6th. And that's how we're going to finish this stream. So if you already saw this in Bill's live stream, go to bed. It's fine. Because we have another live stream happening in just 7 hours. No, this was a Friday, they said. Because they said it. They said it in chat. Isn't this his Friday outfit? Was this Thursday? Because if this was Thursday, this was Friday. Definitely Friday. Oh, he took off Thursday. That's what you're saying, Eileen. I got you. He took off Thursday.
I'm sure I'm the same. Castrutia.
Yes.
Got it. Good morning, ma'am. Ma'am, you're charged with possession of a gambling device, equipment, or paraphernalia. You're facing up to a year in jail and or a $4,000 fine. We are going to do.
And when I was working on editing out the other cases that I didn't want to include, I bumped up the speed a tiny bit, and then I forgot to unbump it. So we're going to be watching Judge Fleischer. It's only at like 1.2 or 1.3 speed. It's not like double speed. It is a little faster though.
Probable cause. You have the right to remain silent. Anything you say can or will be used against you, ma'am. Okay.
I have on February 23rd, 2026, the officer conducted an investigation at Smoky Smoke and Vape Game Room in Harris County, Texas. The execution of a search warrant was conducted. Evidence of 777 gambling machine and 8-liner and a winning of $136.50 with a $2 wager, which is more than 10 times the original wager. The defendant has a prior criminal.
Yeah, I see that. No, she has a prior one that was just same thing dismissed not like 4 months ago.
Right, that's not evidence of probable cause. What we're missing here, what the ADA didn't read is the officers say we tried to get in and couldn't get in.
We somehow go get a search warrant. They go in, and during the execution of the search warrant, they sit down and play the machines. There is zero evidence of cash payout.
I guess I missed that. Guys, what say you?
Yes, Your Honor, I'm looking for the DIMS.
Yeah, I don't care about, for probable cause purposes, I don't care about the last one. But
Yeah, they say specifically.
did they get paid out on this?
Your Honor, there was a winning of $136.50.
Did they get paid out on it?
Your Honor, there's nothing but a payout in the DIMS.
So basically she goes, or whoever goes, I guess the officer goes, plays on the machine, wins $10,000 and then just ups and leaves?
He plays, or he or she plays during the execution of the search warrant. They never get in and recover. So I don't even.
How do they even get the search warrant?
That's my question, Your Honor, but they say they go in and they play.
No. I mean, this shoot first, ask questions later, you know what I mean? No. No problem, cause. I'm with you. Okay, thanks. Department? Right. Hey, good morning.
I'm here for one of my clients, Mr. Chris Martinez.
Okay, just last names for both. Okay, do you mind bringing them up?
So if you have to come up this way, please.
Do you have two cases?
I have one with them, stuffing in from Mike, or helping Mike out in arraignments. He had to go to Fort Bend.
Are they both DWI?
I don't know what Mike did.
So what's the last name on Mike's?
I would defer to.
It's a reckless driving.
Okay, let's do them both, since you're here.
Rocky?
Oh, wait.
And there's Miss Martinez?
I'm not sure.
Cool. Coming up, sir. All right, good morning. Both of you are charged with criminal cases. Both of you are facing, well, Ms. Martinez, you are facing up to 6 months in jail and or a $2,000 fine. Mr. Tachi, you are facing up to 30 days in jail and or a $500 fine. We are going to do probable cause on both of your cases. Each of you have the right to remain silent. Anything you say can or will be used against you. Okay.
I'll start with Ms. Martinez, Your Honor.
Dealer's choice.
On March 1st, 2026, officer in Harris County, Texas, observed a motor vehicle failing to maintain a single lane and failed to use a turn signal. The vehicle continued to drive over a yellow line on the roadway as well. A traffic stop was conducted and defendant, the driver, had red glossy eyes, a strong odor of alcoholic beverage, slurred speech, and looked disoriented. Defendant advised that she had 3 drinks. Standard field sobriety tests were conducted, 6 out of 6 HGN, 6 out of 8 walk and turn, and 3 out of 4 one-night stand. VIC was read and a breath sample was provided. Results were 0.129 and 0.121.
You said she was driving on the shoulder?
So she was failing to maintain a single lane, failed to use her turn signal, and was driving over the yellow line of the road.
She didn't have to put her turn signal on. She didn't make a turn on her, and and she wasn't unsafe to herself or anyone else.
Change lanes.
She did not change lanes.
She was failing to maintain a single lane, and
She was
failing to maintain a single lane. She was not using an indicator when she was going into the next lane.
Well, she didn't. Sorry, Fargo. She didn't. I didn't hear the Tim say she went into the other lane. That all he's saying is that she
But
was.
she did that coupled with she's driving on.
She was driving over the yellow line, Your Honor. I'm looking at what it states in the DIM specifically.
Read it again, if you don't mind, please.
Yes, Your Honor. So this is straight from the DIMS, Your Honor. Officer observed the vehicle failing to maintain a single lane after crossing back and forth over the white striped line back into the original lane. Officer observed the vehicle failed to utilize the vehicle's turn signal as the vehicle was traveling in the middle of the white striped lines. Officer observed the vehicle merge towards another roadway and observed the vehicle drive over the yellow line of the roadway.
So she's merging into another lane?
So it states specifically merge westbound towards the sorry, Your Honor, I'm just looking at the DIMS right now.
Take your time. And weaving within the lane is not a problem, right? If you're going to move to another lane, then you have to indicate your intent. But weaving within the lane, and if you're crossing over a yellow line, I mean, are we to assume that she's changing? You say she's going west?
So she's traveling south, Your Honor.
Does it say that?
She's traveling so officer observed the vehicle continue to travel southbound and then merge westbound towards the 11800 South San Houston Parkway East.
But he didn't say when she merged there that she put on or didn't put on a turn signal. His reference is to when she was within the lane touching the other lane. He doesn't indicate when she merged westbound that she failed to signal.
How do you respond to that?
Your Honor, the officer observed the vehicle crossing back and forth over the white stripe lines. She was failing to use her turn signal as she was going between those two lanes.
That's exactly my point. That the merging.
So I think, so white line is, there's two lanes going south. She's going between one and the other one.
If it's a solid white line or the ones that break apart. I don't think that's
Regardless, whether it's or, you're still going into another lane.
No, but my indication was when she then merged westbound, there was no indication in her DINS report when she turned westbound, whether there was a light.
Well, now you're moving on to something else.
Well, in the lane, you could, like you said earlier.
But this is not in the lane. It's a different lane, right?
She was back and forth between over the white stripe lines back into the original lane, meaning she was weaving in between two lanes.
That's a leap of faith that's what it's saying. He's just saying that she's going
between lanes means two different lanes. Otherwise, he would say weaving within the lane.
I didn't hear that she went into another, but I was checking with the court here.
I think that there's enough for probable cause purposes, it's enough to go forward, Ms. Martinez. I am going to find that there's probable cause to go forward with your case. As a condition of your bond, I'm ordering you not to consume alcohol or illegal drugs. You will be randomly tested. If I find that you're using, I will revoke your bond and put you in jail. Any prior to the license, you have a license?
No prior, Your Honor. Her license is eligible.
Okay, now let's, Mr. Chipachi.
Just for her benefit, that she doesn't have to appear until.
Yeah, I'm going to get that too. Please.
On February 26, 2026, in Harris County, Texas, officer was dispatched to a major accident. Officer observed the two vehicles to be heavily damaged. Defendant informed officer that he was a driver of one of the vehicles and that he had been involved in a collision. Defendant stated he had been testing the vehicle's acceleration to determine how fast it could travel from 0 to 60 miles per hour. Defendant acknowledged that he caused the accident and that the speed reached approximately 76 miles just before impact.
I didn't hear anything that's reckless there, other than speed.
Your Honor, he was testing how fast his car could go from 0 to 60 miles per hour, traveling 76 just before impact with another vehicle.
How
control speed, that's also Class C.
How in a 35 in a school zone, 65 on a freeway, where is he?
Taking like a DINS, Your Honor.
It's gonna be a long day, man. With the reports of the way they're written. My God.
It occurred on Katy Freeway, Your Honor.
So 65 on the Katy Freeway is reasonable.
He was driving 76 miles per hour.
Oh, okay.
He was testing how fast his car could accelerate from 0 to 60 miles per hour on a freeway with other vehicles around. He was traveling 76
So
miles.
tell me, that's still conclusory.
Okay. Listen, seeing how fast your car can go from 0 to 60 is not illegal and is frequently done. Like, don't we all do that all of the time? Don't we always test it to see how fast it can get to 60? That's a normal thing.
How does it become reckless? I understand that there's an accident, but you saying you're testing the wheels, that's conclusory. How, detail and tell me how it's reckless. Other than I know that there's an accident. How? Were there other cars there?
Yes, Your Honor. Defendant stated himself that his speed this is straight from the DIMS, Your Honor, his speed reached approximately 76 miles per hour just before impact.
Yes, everyone, most of the people around the Katy Freeway will be getting reckless driving. I mean, anyone that drives in the Katy Freeway knows how fast people drive. I mean, that's all he's doing is driving fast. Admittedly.
I took my mom on a test drive, right? I was 16 at the time and the Mustang 5.0s were just come out and had no idea. And I slammed my foot on the gas and the car went, and then I immediately took it off, right? Nothing happened. Is that reckless?
Your Honor, he himself.
On your mom or you? So,
You know,
Listen, it's a speed limit. It's not, there's no law on how fast you get to the speed limit. There's no law on that. None.
He himself admits that he was testing how fast his car can go from 0 to 60 on a freeway with other vehicles around. I would argue that.
what kind of car was it?
It was a Dodge Ram, Your Honor.
Dodge.
I understand it's an accident. Does it rise to the level of criminal culpability? I don't think so. It was an accident, right? You put your foot on the gas. You have to specifically intend to be reckless. Like I'm driving like a maniac. I'm weaving in and out of lanes. I'm cutting cars off. I'm going at 110 miles. Reckless, right? Accident is something else. It's a specific intent crime. You have to specifically intend to be reckless, not I put my foot on it and it was an accident and I didn't realize, you know? No. All right, I'm going to find no probable cause on this too. Touch. Please be careful. We have enough accidents on the street. And if you're going to drive, have car insurance. Do you understand? If I find you back here, all right, please.
Ms. Martinez, right this
Okay.
way. All right, Judge, counsel's approaching for page 18. Wiser, Nate?
it's Michael Weirson.
Just last name, please.
Weirson.
Okay.
Good morning, Judge.
Good morning. How are you? Happy Friday?
How are you, sir?
Finally Friday.
I blew a motor on a highway because I was going too fast with my dad in a car once, visiting my sister while she was in jail. She was 14. That was such a good car. Oh, Mustang, Kia.
All right, good morning, sir. You're charged with reckless driving. You're facing up to 30 days in jail and or a $500 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you, sir. Please.
On February 28, 2026, in Harris County, Texas, the officer observed a vehicle going 96 miles per hour in the 60 mile per hour zone. Officer observed the vehicle to make multiple unsafe lane changes without signaling, causing other vehicles to brake abruptly.
That's reckless driving.
The vehicle nearly struck another vehicle and was following other vehicles was following the vehicle in front of them too closely. Traffic stop was conducted and the driver was identified as the gunman.
Yes, sir.
Briefly, I've already gone through the videos on this and showed the state. The videos do not match that. My client did not almost cause a accident. He did fail to use the signal once to move over into a lane when there was no vehicles over there, and he was speeding.
But I can't get into that.
I'm
I
sure
mean, you
those
know,
are fact issue questions.
Sure.
They and I have already worked them out. I just wanted the court to know and be aware. Already did my homework on this. Already showed the state.
Right.
We're ready to go.
Mr. Whipsum, if I find that you drive like this again, I'm going to revoke your bond. I will put you in jail and I'm going to take your ability to drive away from you. Do you understand?
Yes, sir.
No more reckless driving, maniacal, speeding like this, cutting people. If I find that you do, I only have one place for you. Do you understand me?
Yes, sir.
Do you mind filing conditions, such please?
Yes, Your Honor.
I'm going to have you sign a reset. We'll have you take a seat in the jury box while we get bond conditions. Once you sign them, at that point, you'll be free to go. No more. Do you understand? I have no problems throwing your ass into jail and making your bond high. You understand?
Yes, sir.
All right.
Thank you, appreciate it.
Thanks. All right, Mr.
All right, Judge, counsel's approaching for page 13.
Okay.
Quintano?
Good morning. Good morning, Mr. Quintana. Sir, you're charged with evading arrest or detention. You're facing up to a year in jail and a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you, sir. Okay.
On March 1st, 2026, in Harris County, Texas, officer was dispatched to a suspicious person call. Witness stated she saw two individuals wearing all black and ski masks pulling on door handles of vehicles in the parking lot of an apartment complex. Officer located the suspects matching the description given. Defendant fled on foot in the direction away from the apartment complex and proceeded to jump over a fence. Defendant continued evading for half a mile. Officer gave verbal command to defendant to stop. Defendant was then detained.
Sir, you said there's a co-defendant?
There is no co-defendant, but there was two individuals.
So they didn't get the other one?
I don't believe they
Okay,
did.
what time of day or night was this?
It was. It didn't not specify the time of day. I can take we don't have an office report in yet either. But but there's no specific time of day stated in Your Honor.
Mr. Quintano, I'm going to find that there's probable cause to go forward with your case. As a condition of your bond, I'm ordering you not to consume alcohol, illegal drugs, or unprescribed controlled medication. If I find that you do, I'm going to lock you up. I'm telling you now that I'm going to test you within a week. If I find that you're using, and I don't care what it is, you will go to jail. This is not a revolving door, and I'm not going to give you PR bond after PR bond. If you go to jail, that's where you'll stay with a high bond. You understand? What are you doing with yourself these days? You are 17. You've not picked up a criminal case. What are you doing with yourself? Did you graduate from high school?
I'm a senior in high school.
I'm now giving you a curfew. I don't want you out past 9 o'clock. If I find that you do, likewise, into jail you go. So no co-defendant.
We do not have a connected co-defendant, Your Honor.
Okay, and also as a condition of your bond, you're not to go back to this apartment complex and you're not to be in possession of any weapons. I'm also ordering you to either have a full-time job or be in school full-time. But while you have this case open, you're not going to sit at home and play Xbox all day. You understand? It's time for you to become productive, either graduate from high school or do something else productive. But if you have too much time on your hands, what happens? You become self-destructive. You understand? Okay, I'll have you sign your conditions, then we'll give you a reset. Okay, thanks.
All right, Judge, next is top of page 1, Adame.
Did somebody say Will? Oh, wait, never mind.
Good morning, Mr. Adame. So you were charged with failure to stop and give information. You're facing up to 6 months in jail and or $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you soon.
On February 28, 2026, the officer responded to an accident call. Multiple calls for service were made while complainant witness followed the defendant. Defendant's motor vehicle. The complainant witness advised upon arrival that she was traveling on Lauder Road when the motor vehicle attempted to merge. The driver began tailgating her. Complainant witness advised defendant maneuvered his motor vehicle into the left turn only lane, and when the light changed, emerged in front of her and began brake checking her. Complainant witness advised defendant then used side mirror to strike/cause damage to the right front quarter panel of her motor vehicle. The complainant witness then pulled into the gas station, and defendant followed her into the lot, and they had a verbal argument which continued. The defendant refused to exchange information. The complainant witness followed defendant until he stopped at a different location, a different gas station.
Then is that where they caught him? I mean, it doesn't really matter. He just failed to stop. Does he have a license to drive? Mr. Adame, I'm going to find that there's probable cause to go forward with your case. You are not allowed to put your hands down. You are not allowed to drive unless you have a valid Texas driver license and liability insurance in your name. You are not to have any contact with the complaining witness in this case and not to be in possession of any weapons. If I find that you have any more road rage incidents, into jail you go, and I'm going to make your bond high. Do you understand me?
Yes.
I'm going to protect my community at all costs. I don't care who you are. I don't care what color you are.
Yes, he does.
We are going to reset your case to give you time to hire a lawyer. I'm going to have you go to Victoria, sign a reset. I'm going to have you take a seat in the jury box. I'll get your bond conditions. Once you sign them, at that point, you'll be free to go. Come on.
Okay.
All
Do you mind
right,
filing no driving without a license, insurance, no contact with the complaining witness, no
Martina?
weapons, please?
bottom of page 8, Martinez. M is the first name.
Hi. What page did you
Bottom
start?
of 8.
Last name is Martinez, first name is
Stop. I just want last name. Good morning, Mr. Martinez. Sir, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you, sir. Okay.
On February 27, 2026, the officer in Harris County, Texas, observed a motor vehicle with no front license plates change lanes without signaling. Excuse me. The officer conducted the defendant driver. It says RGESS. OAD.
Yeah, so strong odor of alcohol in the breath, red bloodshot eyes, That's okay.
And then the defendant advised he had 4 alcohol beverages. The FSPs are 6 out of 6, 3 out of 8, and 1 out of 4 on one leg stand. The breath showed 0.86,
Okay.
0.81.
You said the stop was for what?
I'm sorry.
What, the stop was for failing to signal lane change?
Yes.
No license plate. No front license.
Got it. Okay. Any prior DWIs? And does he have a license?
No prior license bill.
Got it. Okay, Mr. Martinez, I'm going to find that there's sufficient probable cause to go forward with your case. As a condition of your bond, you were ordered not to consume alcohol or illegal drugs. You're going to be tested. If I find that you're using, I will put you in jail. No more PR bonds. Do you understand, sir? You're not allowed to drive unless you have a valid license. You must also maintain liability insurance in your name. If you don't have car insurance, then likewise, no driving. That is also a condition. Do you understand? Yes. Because you have a lawyer, I will waive your appearance. It is your responsibility to stay in touch with him. If he tells me he cannot get a hold of you, then I'm going to revoke your bond. Do not pick up any new cases. Do you understand? We'll have you sign a reset. You'll get with Roxanne for your bond conditions, and then you're free to go.
Thank you.
Thank you.
Your motion on
Okay.
Ms. Lawrence, there's one part-time at Cheddar's. He works 2 to 3 days per week. They close at 10, and he goes from 5 to 10, but sometimes he has to.
Bring it through, and then we'll tweak it to what he works. Okay? Yes, ma'am. Thanks.
All right, Judge, next is page 3, top of 3, Clifton, come on up.
Good morning, Ms. Clifton.
Good morning.
Ma'am, you're charged with terroristic threat. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you.
On February 28th, 2026, Officer in Harris County, Texas responded to a disturbance call at a pool hall. Complainant, a worker, advised her former coworker, defendant, had an argument regarding a former romantic dispute where defendant stated, quote, "I will shoot you in your fucking eye." Complainant expressed belief the defendant would carry out the threat, and defendant had previously mentioned owning a firearm, and complainant was in fear for her life.
She said this to him.
Yes, Your Honor, she stated this to the complainant.
Okay.
Ricky Bobby.
Ms. Clifton, I'm going to find if there's probable cause to go forward with your case. As a condition of your bond, I'm ordering you not to be in possession of any weapons and not to have any contact with this person. Do you understand? If you do, I will revoke your bond, put you in jail. No more PR bonds for you. Tell me, do you have the ability to hire a lawyer?
No.
Okay. Deputy Williams will give you an application. I need to know everything about you. Whether you have a job, how much money you have coming in, any other sources of income, kind of car, money in the bank, and then I'll take a look to see whether you qualify. We will have bond conditions created for you to sign. Do not leave until you sign them. Okay? Okay. Please.
And the bottom of page
No
3,
contacting
what it
weapons
says, come on up.
and no going back. Good morning, Mr. Thomas. Sir, you're charged with discharging a firearm in a metropolitan area. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you.
On March 1st, 2026, in Harris County, Texas, the officer responded to a call to assist officers and spoke with security staff who advised a discharge of firearm was reported. Witness had seen defendant with possession of a handgun. The officers observed defendant from an adjacent parking lot enter into a vehicle. The search was conducted and both occupants were detained, and the weapon seen by the witness was recovered. On defendant, the officer located an unspent bullet in the defendant's front pocket.
How do you know he discharged a weapon?
Looking at the dims.
I get the umbrella's wet, that you're walking in with wet shoes. It's raining outside, but nevertheless. Does anyone see him shoot?
Security staff, who advised that no injuries were reported, only a discharge from a weapon was being reported. It does not mention that someone saw.
Okay. Mr. Thomas, I'm going to find there's no probable cause to go forward with your case. Home slice. What goes up must come down. And if you fire a weapon up and it comes down and it kills someone, who gets the charge? There are proper places where you can go to fire a gun. You can even go shoot an Uzi, not in the metropolitan limits. You understand?
Yes, sir.
Please.
Drew? Top of 16.
I give you full permission to go fire a gun at my ex-husband's house.
Good morning, Mr. Drew. So you're charged with assault and bodily injury. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
On February 27, 2026, in Harris County, Texas, the officer was dispatched to a family disturbance. Complainant witness stated that while waiting outside his vehicle during a child custody exchange with his children's mother, the defendant approached the vehicle and confronted him, screaming at him and punched him twice with a closed fist in the face, causing him pain. Complainant witness stated after he was punched in the face twice, he was punched several times in the chest area. The complainant witness fell to the ground while moving backwards while being chased by the defendant. The officer observed complainant witness to have
It wasn't her. She was with me the whole time, Josh. She was at my house. So it wasn't her. Look, I'll tell the officers that. She was wearing a pink sweater. See? I know that means I'm not lying because I gave you a detail.
An inflated bruise on the left side of his face and a red bruise on his knees caused after falling down while being chased.
Got it. Sir, I'm going to find that there's probable cause to go forward with your case. As a condition of your bond, I'm ordering you not to have any contact with this person whatsoever and not to be in possession of any weapons, not to go where they live, where they work, where they breathe. If you do, I will revoke your bond and put you in jail. I will not give you any more PR bonds. Do you understand me?
So he's
Stop. I don't care. There's nothing at this time that you can say that will change anything. I'm trying to prevent any further bloodshed from happening.
I understand.
Stop. Just don't. You have the right to remain silent. Exercise that right. Everything you say now, they're going to sit there and they're going to type it, try to prove your guilt. Just don't, just really.
No.
You need a lawyer. Talk to the lawyer, and the lawyer will properly advise you on what you can and can't say, but just resist all urges. It's not going to help you.
It's not for me,
Don't.
for the kids.
Okay. There's a proper way to handle things. I get it, you may have kids. Every father should be entitled to see their kids, but you can't take stuff and you can't take things into your own hands anymore. You've got a criminal case. If you want access to your kids and the other person's not giving you access, go to a family lawyer and then you can get visitation. And if they start playing with you at that point, but don't, the only thing I'm telling you now is don't have contact with the complaining witness. I'm not saying anything about the kids, just this person. You understand? Okay. Do you mind filing no contact, no weapons, no going to where they live or work? And then can you also let the complaining witness know of these conditions so that in the event that there is an issue to let you guys know and then we can take appropriate action, please?
Can I ask one thing?
No, hold on. Let me ask you a question. Do you have the ability to hire a lawyer?
Yes.
We're going to give you time. Before you say anything else, contact a lawyer and they can help you. Don't stop. Just go.
I'm leaving the country.
Okay, so go
That's okay.
contact a lawyer first and then we can work. When you have a lawyer, I waive appearances so that you don't have to come to court and the lawyer can handle it for you. But you need to get on it quick. Okay?
Thank you.
Please.
All right, Judge, bottom of 18, Wilson, come on up.
Mr. Wilson, you were charged with assault bodily injury. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
On February 28, 2026, in Harris County, Texas, the officer was dispatched in reference to an assault. Complainant witness stated he had been involved in a vehicle crash the previous night where he struck a mailbox. Complainant witness returned to the location to provide his insurance. Defendant's mother approached him in an upset manner and stated the debris from the mailbox caused damage to her car. While speaking to her, defendant pushed him to the ground, causing him to strike his head on the concrete. Defendant struck him with closed fists on both sides of his face. Defendant wrapped his arm around complainant witness's neck, causing him to feel pain and discomfort. Defendant stated he was defending his mother from complainant witness and that he tackled complainant witness after he refused to maintain distance from his mother. The officer observed security footage of the incident.
Well, so he came back to Mr. Wilson, I'm going to find that there's probable cause to go forward with your case as a condition of your bond. You were ordered not to have any contact with this complaining witness and not to be in possession of any weapons. If I find that you do, I will revoke your bond, put you in jail. No more PR bonds for you. You understand?
Yes, sir.
Do you have the ability to hire a lawyer?
Yes, sir.
We will give you time. I'm going to have you go to Victoria, sign a receipt. We'll have you take a seat in the jury box. We'll get your bond conditions. Once you sign them, at that point, you'll be free to go.
Judge, we're waiting on the interpreters. That's it for now.
Let's do it.
All right, bottom of 10, Morales, come on up.
Victoria. Dick. How many more items?
There's like 3 attorneys that are not here.
Okay. Good morning, Mr. Morales.
Good morning.
Sir, good morning. Sir, you were charged with assault of a family member. You are facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
On February 27th, 2026, the officer met with complainant witnesses, defendant's brother, who stated he was driving the defendant while running errands when defendant requested to drive. Once defendant started driving, he operated the vehicle erratically. When they got home, complainant witness started to enter the residence when defendant struck him with a closed fist in the center of his chest, causing pain. Inside the residence, defendant attempted to lunge at him in an aggressive manner, but witness's father intervened. Witness stated he saw defendant strike complainant witness in the chest and lunge at him. Sorry. Defendant also told witness, when you go to sleep, I will hit your son.
Do we know if alcohol or any kind of drugs, illegal drugs, played a part in this? And what time of day or night was it? Did it say?
It says 21.7 hours, so military time.
Yeah, okay. Any kind of indication of alcohol?
I don't see a mention of alcohol or any drugs. And again, oh, 1 second.
Your Honor, the defendant stated that he knows his father to be concerned about defendant's past drug use,
Right. Mm-hmm.
and that's from the dibs, Your Honor.
Mr. Morales, I'm going to find that there's probable cause to go forward with your case. As a condition of your bond, I'm ordering you not to consume alcohol or illegal drugs, and I'm going to test you like crazy to make sure that you're not using weekly. If I find that you do, I'm going to put you in jail, and I'm going to make your bond high. Do you understand me? You will not get any more PR bonds. This is not a revolving door. And now within 2 years, you're working number 4. What do we need to do to get your attention? Because apparently we haven't yet. You are not to have any contact with the complaining witness in this case, not to go where they live or work. I'm entering now a magistrate order for emergency protection that identifies Mr. Morales as a protected individual. You cannot commit family violence or an assault against this person, commit an act in furtherance of an offense under section 42.072 of the Texas Penal Code. You cannot be in possession of a firearm. You cannot threaten, harass, use a third party to communicate a threat or harassing behavior to this person. You cannot go within 200 feet of the Broccoli Lane house as well. You violate this, they can file additional charges against you, and a violation of a protective order is the capital murder of misdemeanors. Do you understand?
Yes.
We are going to reset your case to give you.
Jude, I can do that on my computer, but not on my phone. I can type the first 2 names. I put the @ symbol first, and then start typing the person's name. It works fine on my computer, but on my phone, it's like, nah, I can't be bothered.
Time to hire a lawyer. I'm going to have you go to Victoria Center reset, and then I'm going to have you take your seat in the jury box. Expect a test soon. If you fail to appear, then a warrant issues. Do you understand me? When I mean no contact, I mean no contact at all. If I find that you go back to this house, if I find that you have contact, it's going to go sideways for you extremely quick. Hey, Roxana, on Morales, right here, this gentleman, it's on page. Bottom of page 10, test in a week, please. No drugs, no alcohol, no weapons, no contact. That I want to test it in a week, and then not to go back to the house. Good morning, Mr. Blackford. Good morning. Your lawyer is asking for me to set you a bond. I don't know. I've never met you before. I have to get to know you in a very short period of time. Two things concern me. Number one, if we set you a bond, are you going to go back? Number two, are you a danger to our community? If we do give you a bond, are you going to leave a wake of destruction on your way back if you go back? Hold on. Everybody says no. Everybody says no. What we detail and what we find is paper really tells us who you are. Criminal history, do you have any open cases, length
Call Monica. She never says no.
of criminal history, when the last, if you have any criminal history, when it was the last, how recent was it? All this gives us cause to see whether you are a danger to the community and whether you're going to go back or not. If there's just way too much drama, you know what I mean? So all this plays into it. I know what you're going to tell me, that it's little bunnies jumping in the woods. Everybody says that, but paper really tells me who you are.
So, yes, Your Honor, this is for an out-of-state warrant coming out of North Carolina. It's charged of a firearm assault with a deadly weapon, with the intent to kill. In addition, as it relates to the criminal history, the defendant has picked up charges, several charges per year since the year 2019, with a charge dating before 2019. Out of North Carolina, fleeing and eluding South Carolina.
Do we have any idea? I know it's impossible now with the screen blurred out, but do we have any idea the name of the person speaking right now? Any idea at all?
Controlled substance, North Carolina, DWI, California, possession of controlled substance, DUI, North Carolina, driving while intoxicated.
Dang, is that 3 so far? DWI?
About 4. We're out of 2019 and 2022, and we still have more in 2023, 2024, and 2025.
Keep going. I'd like to know. How many more do you got?
2023, North Carolina trespass, 2023, Florida trespass, theft, and burglary. And with those offenses picked up in Florida, there was a failure to appear for those charges.
So he's got charges in Florida, South Carolina, North Carolina,
Indiana. There are 6 states.
Hell no, man. No, you're playing hopscotch with the states, man. No. Not gonna happen. It's way too much drama. I'm sorry. Yeah. I'm sorry. It's just too much. And now you got these cases. I'm sorry, Mr. Weeks. It's just way too much. Has he waived yet or no?
He has waived.
Okay, so, if they don't come pick you up within the 14 days of the day that you sign the waiver, Harris County is going to release you. However, understand that warrant will always remain active until you go back to North Carolina and take care of it. Do you understand?
Mm-hmm.
Okay, good luck.
Now, the 14 days is that,
From the day you waived. When did he waive?
March 4th.
So that's 2 days ago. So you got around.
I sound embarrassed, but with that also being said, is business days or is it just regular days?
It's everything.
No
Or is
way,
it-
I know
business
my
days.
car.
Each day, yeah.
I know my car. I don't run out of gas. But if my normal gas station would ever be closed, oh man.
So today I should be expecting 14 days.
I know, I'll let you guys calculate it, man. Okay.
Thank you, Your Honor.
Thank you. Thanks, guys. Ready?
Yes, sir.
Just the last name. Who do you got?
I got Miss Stone.
Oh.
Miss Stone.
What do we do with Miss Stone?
Well, Your Honor, I think she would like to explain some things. We have some issues with the test. She's supposed to test twice a week. They have car problems, financial problems. And I don't know if she's supposed to pay each time she goes and tests.
No, she don't pay anything. We waive everything. Always, for every person. I waive all the money for
Can I
everyone.
bring her up? You know?
Sure.
Do you mind? I think we can work it out, Judge. She has been very communicative with her attorney. She's staying in contact with me.
So it's been roughly around 40 days. You failed to appear for the last drug test. All right, so I'm gonna give, just to be on the, give caution, I'm gonna give you another 2 weeks to clear out. But at that point, if you're not clear, You understand? Okay, all right.
Thank you. Maybe it's good.
But 2 weeks, Mr. Beaton.
That's it. 2 weeks. You gotta drink water.
All right.
You gotta exercise. You gotta do.
Not thank you, Bobby. Wait, hold on. Bobby, when you say, I'll order 3 for you, Granny and Kathy, I need to know if this is spicy. Because I don't trust you at all. So I feel like this is something outstandingly spicy. So no, thank you. No, thank you. No, Bobby.
Okay. Okay. Mr. Hamilton, coming up. Good morning, Wisconsin. Happy Friday. It's finally for a man. Finally. Good morning, sir.
What, Bobby? I got a promise for you. If I ever cook you dinner in this world, in this lifetime, if I ever say, here, Bobby, I made this for you, I freaking promise you don't eat it, because that's going to be dog food. It just is. I'm going to cook you dog food.
Sir, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you.
On February 27, 2026, approximately at 1:52 a.m., an officer in Harris County, Texas, observed a motor vehicle traveling without lights at night. There was a search conducted. The defendant driver advised he was coming from a company party and had a few drinks. For the SFST, it was a 6 out of 6, 2 out of 8, and a 3 out of 4. Driver's license is eligible.
They like pull them over and they just start searching?
A traffic stop was conducted.
Is this the thought police now? Driving while black or what?
You travel without lights at night.
Great. That doesn't mean you're intoxicated. That's it?
He had a strong odor of an alcoholic beverage, emitting from his breath, and had glossy eyes, slurred speech.
Okay. That's more. So then they get them out. Do they do field sobriety?
Yes.
What were they?
6 out of 6 HGN, Your Honor, 2 out of 8 walk and turn, and 3 out of 4 one leg stand.
Any priority to be on?
No priors, Your Honor, and the driver's license is eligible.
So do they take him back? Do they do any breath tests, blood tests?
The GIC was read and he refused to provide a sample, Your Honor.
Got it. So do they take blood or no?
Yes, Your Honor, he did blood.
Okay. Mr. Hamilton, I'm going to find that there's probable cause to go forward with your case. As a condition of your bond, you're ordered not to consume alcohol, illegal drugs, or unprescribed controlled medication. I will randomly test you. If I find that you're using, I will revoke your bond and put you in jail. No more PR bonds for you. You are not allowed to drive unless you have a valid license. You must also maintain liability insurance. That is also a condition. If you don't have car insurance, then do not drive. Do you understand? Because you have a lawyer, I will waive your appearance, but you must stay in touch with her and she'll tell you if and when you have to come back to court. If she tells me she cannot get a hold of you because you're playing games, I will revoke your bond. Just stay in contact with her. All right? For now, we'll have you sign a reset. You'll get with Roxanne for conditions and then you're free to go.
Thank you, Judge.
Please. Yes, ma'am. Thanks. Ready? You said in the jury box?
In the jail box.
Ah, okay.
Josh.
Weird.
I'm not telling you to tell me how fast it takes you to go from 0 to 60 when you go pick up your son. I'm not telling you to do that.
They didn't give a PR box?
No.
Why?
I'm not sure.
Let's read it. So the magistrates always have to justify why they do. Let's read it. So it says here, I find by clear and convincing evidence that there are no non-financial conditions of bond and reasonable alternatives to pretrial detention that will suffice to reasonably assure the safety of the victim. So 2/27/26, complaining witness stated during a verbal argument, defendant pushed complaining witness. Complaining witness fell, bruising back. 3/4/26, defendant took complaining witness's phone as complaining witness was calling law enforcement and slammed phone to ground. Defendant stated, if I go to jail, I'm going to kill you. I'm going to shoot you.
So he's indicated to me that he's already paid the bond. I think it's just hasn't posted yet.
This is Gonzalez.
So I indicated his brother had actually paid the bond yesterday, but it hadn't posted yet.
Well, I think that there are other alternatives that we can do to kind of protect the complainant is to ensure that he doesn't go near her. And in the event that he still takes matters into his own hands, at that point, we'll put him in and make it a really high bond, and I'll bring him out and I'll tell him, I firmly believe everybody deserves a chance. Do you see any criminal history on Mr. Gonzalez?
I'm running the CIC right now, Your Honor, but it does not look like it.
That's nuts. Hey, can I have Mr. Gonzalez, please? Do you need a translator?
Yeah. So he said that he paid, that his brother had actually paid the bond yesterday, but I didn't see that his bond was posted.
Do you want me to wait or do you want a PR bond?
Well, so I guess the question would be, if he has paid the bond, would you be willing to waive the GPS monitor?
Hell no. That's what, I was gonna give him a PR bond, but I'm gonna put the monitor so I know he doesn't go anywhere near it. Because that's the only way I can really ensure that I'm not gonna take his word for it.
I'm sorry.
But I'll.
If we can do the PR bond.
Yeah, I'm happy to give you a PR bond. I just want to inform him that if he starts just doing things he shouldn't, then.
I'll play with you. Eileen, we'll stream it.
Hey,
That was
Mr. Peden,
so
we'll
good.
randomly do once a week.
Me and Eileen are gonna
Once a
play
week randomly.
Once a week randomly.
So just have her ready that she can get called, okay?
Absolutely.
Yeah,
Thank you, Judge. That's
for
what
sure.
I was
I figured it was. How's jail?
Sorry?
How's jail? It sucks, right?
Yes, sir.
It's supposed to. It's not supposed to be fun. It's supposed to be there so when we find that people are dangerous, they're damaging or hurting our community, this is what we have at our disposal to ensure that our community is protected. That said, I'm a firm believer that everybody deserves a chance. You have not been given a chance. I'm willing to give you a chance, but you're not to have any contact with this person whatsoever. Do you understand?
Yes, sir.
I'm entering in now a protective order that limits you or bars you from having any contact, going within 200 feet of where she lives or where she works. And I'm going to put a monitor on your ankle so I know where you are. If I find that you go near her, where she lives, where she works, if you attempt to have contact with her, then we will have issues. I'm going to give you a PR bond today, but this is not a revolving door. I'm not going to give you a PR bond after PR bond. You have one. If you violate, then I'm going to put you back in jail. I will revoke the PR bond and I'm going to make your bond high. Do you understand? I don't know who you have in your life, but if I make your bond $20,000 to $30,000 and you don't have anyone to pony up that money, do you understand? When I mean no contact, I don't care who initiates the contact. If she calls you, do not talk to her. If she texts you, do not reply. If she comes to your house, don't answer the door. You're the one that's going to go to jail if you have contact with her, and I don't care if she initiates. No contact means no contact. Do you understand? As also as a condition of your bond, you are not to be in possession of any weapons whatsoever.
Yeah.
If you have a weapon likewise, you're involved. You violate this, they will file they can file additional charges against you. And a violation of a protective order is one of the worst misdemeanor cases you can pick up. Do you understand? The only other thing I'm going to advise you now is that you must stay in contact with counsel. If he tells me he cannot get hold of you because you're ducking and dodging, likewise, a warrant will issue. You understand?
Yes.
I'm not asking much from you. I just want my community safe. And if you can adhere, then you and I will be best friends. Understand? Okay. So we'll grant him a PR bond now. He'll get a monitor prior to release. And then after that, he'll be with you. Okay. Give me a sign. Good morning, Mr. Mendez. Sir, you're charged with evading arrest or detention. You're facing up to a year in jail and or a $4,000 fine. You have worked out an agreement where they're offering you 30 days in jail.
I don't see that. I don't see you over explaining at all. I think you chat lovely.
With credit for the 10 that you have done. You need to understand that this charge will go on your record. It will be there forever. Because this is now a conviction, if you ever pick up another evading arrest, the next one will be a felony offense and you're looking at years instead of days. Do you understand? You are giving up the right to a trial, right to compel witnesses to testify on behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up your right to appeal. Once you accept this agreement, you can never change this or undo this. Is this what you want to do? You want to plead guilty to this offer? Are you guilty of this offense?
Yes, sir.
Okay. I'm going to find you guilty, sentence you to this agreement. Does this take care of the
Yes,
felony?
Judge, pursuant to this agreement, they're going to dismiss the felony, but the prosecutors here aren't comfortable doing that, so they're notifying the felony prosecutor.
Okay, yeah, right. You know, here's the other thing. Your bond is 2501. It would only cost you all of probably $200 to get out on bond. These are things you need to recognize when you're out there in the free world and there are shenanigans afoot. No one's willing to even pony up $200 to get you out of jail. So the next time you're out there, consider this. Do you understand? Good luck.
Thank you, Judge.
You know, speaking of Texas Penal Code 42.072, I think I'm in love with Victoria, but she's married. But I'm not going to stalk her. I'm not going to. Just saying. I think I'm in love with Victoria, but she's married. Maybe I should stalk Michael. From Pennsylvania. That would be hard to do. Unless someone would like hack into all the cameras up on the traffic lights. I liked watching Judge Fleischer at super speed like that, but I'm not going to do that again. It was an accident. It was just an accident. That's how I roll, and then I undo everything before I give it to you guys, which is probably why sometimes the volume isn't right. I don't know. I don't know why some clips, because I don't record court. Like I don't screen record it. I grab the stream, the full stream. So there's no reason for it to separate. Like if you would, Judge Cutie Pie. I love Judge Cutie Pie. I haven't seen him at all. I've stopped getting Colorado almost completely. I just have so much content that I have to get through that I just don't have time with Indiana and Georgia. So, but I haven't seen Eric Johnson in so long. I forget how long his beard got and how curly his mustache might have gotten by now. Or maybe because it's getting warmer out, he got rid of it. I don't even know. Ugh. All right. Tomorrow's Monday. It's a new week. I can hone in on some Colorado. I can. I just have 300 dockets in my queue right now to look at of Indiana and Georgia. That's why we're so many days behind. But I had so much more to show you tonight, but it's already been almost 2.5 hours. So I have to stop. Thank you so much for coming out, guys. I really, really appreciate it. I do. Josh, I hope you drive super safe. Thank you to the new people who came out today. Congratulations to the ones who got memberships. You guys will like some of the content in the memberships area. But behave. We have another stream in 6 hours ish, something like that. So, but I won't have Judge Fleischer then. I just don't have any more ready. So I will see you guys in a couple hours, or I will see you tomorrow or next time. Martha, it's so good to see you again. You have no idea. You have none ideas. Love you guys. Bye.
Well, I thought I'd write a happy song. I found a chat room where I belong. You don't know how much it means to me. With such a groove, I'm less lonely. Oh, Kathy's the creator. She's leading the way. At Court Vibes, we laugh and we stay. Her smile shines bright. She's got that grace. Come join the fun. It's a welcome and play. I can count on distraction from my pain, 'cause this creator takes you there and back again. Kathy is the heart here, always in stride. Her work is hard, but her her joy she can't hide. Oh, Kathy's the creator, she's leading the way. At court vibes, we laugh and we stay. Her style is classy, she's always top shelf. Don't take my word, come and see for yourself. Her cases are new with a twist or two. I really like them, I believe you will too. A little lifeline passed along in rhyme. Why don't you join us? It's a guaranteed good time. Oh, Kathy's the creator, she's leading the way. At court vibes, we laugh and we stay. Her smile shines bright, she's got that grace. Come join the fun, it's a welcoming place. And so in conclusion, I'll wrap up this song. I hope I didn't miss anything that would be wrong. Hope I see you around. Don't stay on the shelf, join in the laughter. Come and see